The Chief Magistrates Court in Uganda's Northern District of Pada on Thursday, January 22nd, had an election petition for a mandatory vote recount filed by a former Al County Member of Parliament, Samuel Odonga Otto. Otto, who is seeking a parliamentary comeback, contested as an independent candidate. He sought the recount after he lost the election by a difference of 26 votes to incumbent MP Christopher Komakech, a son of the late former Deputy Inspector General of Police Major General Paul Lokech. Section 54 of the Parliamentary Elections Act 2005, as amended, provides for a mandatory vote recount when two or more candidates are separated by less than 50 votes. So in his petition, although sued the Electoral Commission, the Pada District Returning Officer Dr. Eric Gimi and MP-elect Komakech, the application is brought under Section 74 of the Parliamentary Elections Act Cap 177 and Order 52, Rule 1 and 3 of the Civil Procedure Rule outlined in Statutory Instrument 282-1. Court documents signed by Pada District Chief Magistrate Martin Kidia granted the application and fixed it for hearing on January 22nd. A letter bearing the signature and seal of the magistrate states that the ground for the application have been supported by affidavits of the applicant Otto, Moses Odongo, Vincent Okwera Omona, Pavio Ojok Kirama, Charles Otto Lalobo, and Alfred Peter Okero. The application sought three orders from court: a recount of the votes of the January 15th parliamentary election, supervision of the recount by court, and course of the application. According to the final tally declared by District Returning Officer Komakech, polled 10,455 against Otto's 10,429 votes. Otto's application alleges that were numerous irregularities during the voting and counting processes in various polling stations, which affected the accuracy of the final results. It also says several votes clearly ticked in favor of the applicant were declared as invalid at the time of counting and tallying on the ground that the biometric voter verification kit scanner had failed to recognize them. It is just, fair, and equitable that this honorable court orders a recount to ascertain the true results and will of the people of Arul County constituency. Read Otto's application, which is dated January 19th and filed on 20th January 2026.
And he was declared the winner, having polled 10,458 votes, as opposed to the 10,420 votes, and therefore won him by a margin of 26 votes. He stated that, much as it is true, the letter under Annexure B was received. This was after the declaration results by the returning officer, and that there was no irregularities made in the process. The reason why the applicant did not immediately complain after the counting of the results. He therefore praised that the application did it in its due process for lack of votes. The second respondent opposed the application in substance, save for the results declared that saw the first respondent emerge as the winner. He therefore stated that the application is based on false votes, and further that once results have been transmitted to gazetted, the recount cannot be ordered. He prayed for dismissal of the application with process. Representations, both parties were represented. Council Akena Kenneth represented the applicant, Council Komakech Geoffrey, their first and second respondent. For the first respondent, and Council Masuduli for the second and third respondents. All the advocates made correct submissions. Two issues were framed. Whether there are any grounds to justify the grant of the application. Two remedies available. Submissions. Council again gave a history of the process that the applicant wrote to the side respondent who was closed with the duty for the conduct of a mandatory vote recount. But the third respondent refused. He relied on Annexure B, which is the letter to the side respondent requesting for a mandatory vote recount. From the above, Council seemed to suggest that failure of the returning officer to conduct a mandatory recount would also suffice as a substantive ground for an order of recount in the vote. Secondly, that in a number of polling stations, there were a lot of irregularities. Strictly, there were a number of invalid votes which were invalidated on account of disregarding the intent of the votes of the voters, which now require the Senate court to order for recount and understand the intentions of the voters, which should have been butchered in the process. In response comes for the first and second and third respondents did not dispute this letter, but only argued that the data was submitted late after the results were already transmitted to the second respondent for gazetting at around 0:48 p.m. and later was received from the cities at 1:38 p.m. Their submission, they suggested that once the results were transmitted, the second respondent had nothing to do with the results. Secondly, that upon signing of the declaration forms by the agents of the applicant without protest, they signified assent of the applicant, and coupled by the last of the applicant himself, to immediately raise to the occasion before transmission day. Before transmission was enough to prove that the application comes rather than assent. Examination. The application for vote recounts is a two-course exercise. The first course requires establishment of sufficient grounds or good cause to the satisfaction of the court to warrant a recount. And the second course is for establishing the tenability of the exercise based on the integrity of the custody of the ballot box. The court shall declare a recount if the ballot boxes have been at least substantially leading to the ordinary reasonable conclusion that there is a record of operations of the box bearing on the expectations from the returning officer as envisaged under Section 71 of the Parliamentary Elections Act and the University. In the case of Moses vs. the court frowned at the process adopted by the magistrate theory that all the ballot boxes were opened at once. There was no proper inspection to ensure that all the boxes had been properly secured. Some as the evidence showed were not properly sealed. Others that were included were not from governance. Other than a mandatory vote recount, whose demand by the applicant is almost a given under as long as he shows that his score as compared to the winning candidate as declared by the returning officer falls within the threshold of impossible of the vote recount is true. Vote recount differential magistrate on the other hand are governed differently. Section 74 of the Parliamentary Elections Act states as follows. Within 7 days after the date on which the returning officer has, in accordance with Section 77, declared as elected the candidate who has obtained the highest number of votes, any candidate may apply to the Chief Magistrate for recount. We have grounds to justify this recount. It was emphasized in the Kasiban's case, which I've already referred to, that the application for this nature is a two-step process. First, the court hears the application for the recount. The applicant must justify making it by satisfying to the Chief Magistrate with good reasons why the court should order a recount. If the Chief Magistrate is not satisfied with the applicant's reasons, he or she shall dismiss the application. And I've underlined the words with good reasons or why the court should order a recount. I don't want to ever explain why the land judge opted for the phrase good reasons and not better or best reasons. But the obvious answer, I think, lies in the burden of proof, which must be satisfaction of the court, which is on the balance of probabilities. That then this application present good reasons to justify recount. In the absence of any fiction, to my knowledge, for the phrase good reasons in respect of election disputes, what recount, I suppose, it must be asymmetrical for other reasons that can upset the conscience and belief of court from what is arithmetically represented as normal. And this upset must be able to satisfy court on a balance of probabilities, and yet again, there is no required number of such reasons. Even one reason can suffice. From the evidence that is presented, the applicant says there was deliberate disregard of the intention of his voters in the way they ticked the vote, and such votes were declared invalid, and this affected his final score, which would see him possibly declared the victor. He tabulated the affected polling stations as below. Layet, Helen, Compound, 18 votes, Kinene, Buko, 20 votes, Badian, Primary School, 17 votes, Orurung, Paguel East, Paguel West, Ogem, South, 10 votes, Christchurch, Primary B to Z, 10 votes, Acholi P, Mango Tree, A to I, 13 invalid votes, T Attack, polling station, 10 votes, Arin, polling primary school, 10 votes, Anyabian, primary school, 12 votes, Quira, Market, 12 votes, Boro, Ogan, 10 votes, TA, Central, 9 votes, Ade, Gabon, 9 votes. A tabulation of about 175 votes was ascertained. From the above evidence, I found cooperation from these witnesses, Mr. Odonga Moses, Okero Alfred Lane, Ojok Pabio Klama, Okwera Vincent Omona, who directed the man the affecting polling stations by way of coordination. The evidence clearly has sufficient source to the already denied the preferred source with the resultant effect of making it a very test. And compared with the reply as presented, and more so, the small margin of votes between the two candidates, which is 26 votes. From the submissions and the arguments, the arguments were central on the votes that are said to be denied in favor of the applicant on account of disregard of the intention of the voter, which in my view is an issue of arithmetic consideration and not failure to observe the electoral laws as submitted by respondents, which would greatly fall in the purview of a fully fledged election petition. Therefore, I find such circumstances to favor good reasons for the order for a recount, because it is only through a recount that we can be able to ascertain whether the intentions as claimed were reached. However, both lawyers addressed me on the parameter set out in the case of Vianima Wing versus Ngoma, which set out the conditions to look out before an application of this letter can be granted, and I shall reproduce a few points. The trial judge then held earlier, notwithstanding the fact that Section 56, now our 76 of the Immigration Edition, or the Parliamentary Elections Act, provided for a period of 7 days from the day on which returning officer declares the results of the election, within which a candidate may apply for a recount of the votes. The decision to apply for a recount must be prompt and without delay after the returning officer has declared the winning candidate. That decision must not be as an afterthought. The candidate intending to apply for recount under Section 56, which is now our 74 of the Act, should immediately inform the returning officer of his or her intention to apply for the application, as indicated under Section 3 of subsection 9, which is now our 74.3. They not serve to arrest the delay, the rapid flow of the electoral process to enable the recount for within its proper location to that process. It is true from the declaration of this application, the request was made at 1:30 a.m. when the results were declared around 12:48 p.m. The lapse of about an hour cannot be regarded as inordinate delay, and even then, the respondents have not said the ballot boxes are not within the jurisdiction of the Sovereign Court, which was the only evil intended to be cured under that law.